Welcome back to HOA Hell. I'm your host, Michael Kushner, and with me today is Senior Associate at MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thanks.
Good.
Today, Sam, we're going to talk about management companies. Okay? With the exception of really small HOAs, I would say that most HOAs with, I would say, more than 25 homes, which is the vast majority of them,
Right.
have management companies at least doing certain services for them. Most of the time we see, and certainly the larger HOAs, which is the vast majority of them, the management companies do a lot.
They do.
Okay, and it's because they do so much, and because they are so involved in every aspect of HOA life, and in fact, they're more often directly interacting with specific members than the actual board members are.
Absolutely.
I think it's important to talk about the role that management companies play and the role they're supposed to play, and when HOA boards have yielded too much authority in violation of their fiduciary duties and the law.
And that can be a source of confusion to many homeowners and
What do you
many
mean?
of our clients.
What do you mean?
They don't fully know where those lines start and end, because the first line of communication oftentimes is the management company and the managers, yet they will sometimes directly reach out to the board members. They don't know when to contact the manager, especially when there are delays in responsiveness or they're running into issues.
Right.
I mean,
and by the way, homeowners have a right to reach out directly to directors and skip management. They have a right to do that. But and I agree that that's a source of confusion. But I think another source of confusion, and we'll talk about this a little bit. We'll get to what we're going to cover in a minute. But I think another source of confusion is, since it's the management companies that are often communicating directly with homeowners, sometimes there's confusion about who's really making decisions or who's supposed to be.
Absolutely.
Who's the one that I'm being punished by? Is it the management company that's punishing me, or is it the board that's making it? So there's confusion because nobody ever just makes it easy. Like, here's how it's supposed to work.
Yeah.
So hopefully this podcast will do that. We're going to educate you as to how it's supposed to work. And so, because then you'll be able to recognize when things at your HOA are not being done right. It's that simple. So this episode, I guess we can say we're pulling back the curtain, right?
Right.
So we're going to talk about what management companies actually do and what they don't, okay? How they're hired and fired, or how they're supposed to be hired and fired, okay? What their contracts usually say. We'll probably touch on that if we have time. We're going to definitely discuss red flags that you can look for when management is not. When you've got a problem with management, we're going to give you red flags to look out for to indicate that there's a problem there. And then what you can do as a homeowner if any of those red flags pan out, okay? So we'll get into it. Let's do that. We'll start with who's really running your HOA, okay? So let's start with a very basic truth, and if you tell me if you agree with this, okay? This is a truth I think that too often goes unheeded, and that is that management companies are not in charge.
Oh, absolutely.
Okay?
Yeah.
The board of directors to your HOA, the elected board of directors, they are the ones that are supposed to be making decisions on behalf of the association. Only the board has a fiduciary duty to every one of you, the members. The management company, and in particular the managers assigned to your HOA, because management companies work for multiple HOAs, right? They don't have a fiduciary duty to the individual members. If the management company contract involves dealing with any of the finances or writing checks, the management company will have a fiduciary duty to the board, to the corporation as a whole, but not to individual members like you. But every board member has a fiduciary duty to every individual board member like you.
Exactly.
So the very, very most important thing to remember is that the board of directors are the ones who run your HOA.
Governance as board of directors, then the delegation of certain administrative and or communication related liaison type aspects are delegated to.
Right. And the best way to remember the difference is you have to elect your board members at properly noticed elections, and we talked about the election rules in a prior podcast that we just did recently, okay? You do not elect your management company. They're selected by the board. So the board answers to you, the management company answers to the board, and they can be hired and fired at will with no vote of the members, Okay? So it is appropriate for boards to delegate certain duties or activities to management. That's not a problem. That's what they're there for. They're also there to provide advice because there's a recognition that the board of directors of your HOA, unlike professional for-profit corporations, they are lay people who don't really know what the law is. The management company's there to kind of educate them. Here's how meetings are supposed to work. So let's
and many of them have day jobs, and they're busy.
Board members, you mean?
Board members, yeah, they have day jobs as volunteers, like you said.
That's right.
And guess what? They can possibly stretch themselves into their private time to the extent it takes to run
and
ministerial aspects of the day to day with most
right.
HOAs. Yeah.
And here's the thing with management companies. Under current law, and by the way, this might change. This is up right now, I think, in committee. Is a change in the Davis-Sterling Act regarding management companies. I'm not going to get into it today because it's not the law yet. Okay, but theoretically, the management companies are supposed to have pretty intricate knowledge of the Davis-Sterling Act and Rob's rules of procedure, and they're supposed to be educating board members. That's the theory. Okay. But there are not licensing, there aren't a lot of any strict requirements regarding who can be a manager for a management company for an HOA. And so there are really a lot of management companies. It's the small ones, all right, the regional or even smaller than that, like city. They only represent a few HOAs in a particular area. They aren't the ones that are statewide. We've seen lots and lots of really bad managers that don't know the first thing about the Davis-Sterling Act, and they have no business doing what they're doing. They just don't.
Right.
Even though they're supposed to. That's a
real
real recipe for disaster.
It is. And you see a lot of turnover with those managers. They don't last very long oftentimes.
But it's the ones that do,
Yeah.
especially because if they're insiders.
Yeah.
If they're connected or related in any way to somebody on the board, they do. And that's a problem. We saw that in our embezzlement episode. Okay.
Yeah.
So, but for the most part, and we're going to talk, we might touch briefly on certain things that management companies are never supposed to do. Okay. There are certain, and I might let Sam do this, but there are certain duties that a board of directors has that are not delegable at all. They are never supposed to be delegated to a management company, and yet so often they are. But we're also going to talk about the things that are delegated. And one of those things that are rightfully delegated is, look, we don't have time. We work full-time jobs. We're just volunteers. Yeah. We don't have time to write these letters.
Notices, yeah.
You write the letter. So, when a homeowner needs to be disciplined, we'll give you the information. You write the letter to that homeowner. You communicate. Because they've got templates and all that sort of thing. So that's often one of the things that a management company can be tasked to do. And then there are things that they're not allowed to do. They are not supposed to be creating the budget.
Yeah.
They're not. That's supposed to be between the board and the CPA, let's say. Okay. But anyway, that's kind of the basics. Okay. Management companies take on certain duties so that the individual board members don't have to, because it's not supposed to be a full-time job for them. They have other jobs.
Exactly.
So let's go into what is it that management companies specifically actually do. Okay. So the first thing to understand is that everything the management company does is governed by what? A contract.
A contract, yeah.
Okay? So if there's no written contract between your board and a management company, and you have a management company, that's a big problem. But in this contract, what are usually some of the things that are covered?
Well, typically, aside from the normal terms of contractual agreements, they typically outline a limited scope engagement for these managers to engage in, let's say, administrative things like receive communication from homeowners, respond to them, advise the board, act on at the behest of the board when we need you to, let's say, be the intermediary with either homeowner or legal counsel or any other vendors, third parties,
or maybe to please attend all meetings and take the minutes for us.
Right, take the minutes
and advise if you see we're doing something wrong, we're violating Rob's rules of procedure. Educate us.
Routine maintenance issues, kind of marshal some of those vendors.
So you talked about, I think I'm going to jump on one of the words you said because I like it. And that was it. The contract, number one thing is it's going to outline scope of duties. Yeah. Okay. So let's focus on that for a minute. If I had to break out, there's two very broad categories of contracts that a management company will fall into. And I think the vast majority, maybe in the 90% of all management companies, their contracts with the HOAs fall into one of two categories. Either a full service contract or a financial only contract.
A limited one, yeah.
A full service contract is going to include a very wide scope of duties to include some of the things you brought up. We want you to be the main liaison between us and our members when it comes to discipline. We want you to be the liaison between us and council and certain things. We want you to guide us on at meetings. We want you to take the minutes for us and guide us as to how to run those meetings, be available for questions, et cetera, et cetera. That's going to be more like a full service contract. Then there are HOAs, and this would be more along the smaller HOAs.
Exactly.
Where, look, we need help with some of the financial obligations or the disclosures that we're obligated to make every year. Those are confusing. You need to guide us on that and help us with those and put those together and help us put together the budget and then tell us what we have to serve and get it out to all the members. So that would be more limited, and that would be what I call a financial only contract. But for the most part, all the contracts fall into those two categories. Okay. Right. So with that out of the way, we're focusing today on larger HOAs. And when I say larger, I don't mean really larger. I mean 50 or more homes. Okay. Because I don't want to focus on the small ones because those are not the majority. And so we're going to focus on full service contracts, which is the one that you jumped on. Okay. And so one of the first things that contract's going to do is going to outline in general. It's not going to be too specific because you can't think of everything. It's going to outline pretty broadly a scope of work. And it's going to list giving examples of all the things that they do. Okay. So what does that include? You started to name some. Prepare notices for us. Yep. Any required notices that have to go out, you make sure they go out. Tell us what, and you give us your templates. You prepare them, okay? You put the stamps on, or however you mail them out. You take care of that. You're the one that goes to the bulletin board and posts all the agendas. You write the agendas. We tell you what we're going to talk about, and then you make sure it's in its proper form. Yep. And then if we have a central bulletin board outside our gates, let's say, you post it. That's what the management companies do, okay? We want you to respond to all the member requests. I have the staircase over here has got a slippery spot, or somebody spilled something oily here and it needs to be cleaned. They'll handle that. Okay, maintenance requests. Okay, if you're in a condo and hey, I'm having a leak, they're overwatering and it's coming under my floorboards. That goes to the management company typically because the board members they're at work. They don't want to deal with that. So it goes to the management company. They're going to coordinate maintenance requests. Hey, we can send a vendor out at this time. Homeowner, are you there? Okay, we're going to, giving you a 24-hour notice, 48-hour notice. We're going to have somebody there. That's going to be the management company most of the time, okay? They facilitate the board meetings. They prepare the notices, the agendas. They take the minutes often. Yep. It could be the secretary, but often it's the manager if that's within their scope, okay? They'll handle billing and assessment. So keep track, right? Of who's making payments, if there's a payment plan, or if it's who's paid, who's given us a check. Right. They might even receive the checks and stamp them and get them deposited into the account. Okay. They might have a little electronic check reader right at their offices, and they handle all. And they've got a bank account. They've got access or view access, whatever, to the bank account for the HOA, and they can make deposits and look at stuff. So that's one. They're going to maintain basic records along the lines of stuff we've talked about, right? They might even help coordinate elections. Keep track of nominations, make sure the board, hey, it's time to, you've got this 120-day timeline. That's our starting timeline, and you got to make sure that the nominations go out by this date and this date. They're supposed to be doing that, right? Now, let's talk about things they're never supposed to do, okay? Sam, does the manager have any legal authority to act on behalf of the HOA beyond their required scope?
No. Definitely not. No.
Because they're not fiduciaries.
No.
Right?
Exactly. Yep.
Okay. Can they make decisions that have legal consequences that are outside their scope?
No.
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 Okay. Can they fine a member?
No. I mean, no, they can't. That's a board decision.
Right. And it has to come at a hearing.
Exactly.
They
can provide notices of that eventually.
Right, of course.
Yeah.
Now, they might be invited to appear at a hearing, but can they participate in the hearing as a decision maker, or can they question? No, it's not their role. Okay? If I was ever, and I've never been to one as a personal HOA member, I've never been called to a disciplinary hearing. But if I ever was, or if we were there in a professional capacity, and that happens, we have clients that ask us to come with them to discipline hearings, and a manager ever tried acting as a board member, either by asking questions or examining the witness, I would shut that down quickly and say, you shouldn't be talking.
Yeah.
You're here to observe and advise on Rob's rules.
That's exactly it. Yeah.
Other than that, you need to keep your mouth shut, buddy.
Yeah.
Because
Advisory.
you're not a fiduciary,
Yeah.
and I don't owe you anything. You keep your mouth shut.
If they're privy to information or anything from chronology or something that adds to the discussion,
If the board
advising
asks,
the board, if the board asks, that's different.
But don't deal with me.
Exactly.
That's right. You are not a decision maker at all. In fact, I would go so far as to say that to the extent that management appears in an executive session meeting, which they can, take the minutes there, they should not be participating in the discussion about what should or shouldn't be done unless it's procedural only. Guys, you can't talk about this.
Agreed. Yeah.
Yeah. If we did a recent, I think it was a short. I think I did a short podcast recently on, it was a short, on what can and can't be discussed at executive session. If a manager is in an executive session meeting and the board is engaging in a conversation of a topic that is not appropriate for executive session, it would be well within their scope a lot of the time to say, guys, that's outside the course and scope of what we're allowed to talk about at executive session. But they should not be participating substantively. Procedurally, yes, not substantively.
Yeah.
Okay, and if they do, that's a no-no. These are legal realities. These are things they can't do. Doesn't mean they don't do them all the time. That's the problem. That's why we're doing this podcast.
Exactly.
But they shouldn't be, okay? And so in practice, it happens. It ain't supposed to. So now, let's talk about, Sam, let's talk about how they're hired and fired, okay? So who decides on what management company to use? Because there are many in the state of California. There are dozens, okay? And there are probably 10 or 15 or 20 that names come up the most, right? These are the big ones that represent lots and lots of HOAs from San Francisco Bay Area all the way down to San Diego. They've got offices everywhere in the state. They even might have, there are management companies here that are multi-state management companies that represent HOAs in Arizona and Florida and name a state, Texas, right? So you've got some really big ones that are multi-state. You've got big ones that are statewide. And then you have smaller ones that might be Southern California or even smaller, San Clemente only or Laguna Hills, right?
Exactly.
Regional or even city.
Right.
And, everybody has to start out somewhere, all right? So you start small and you can grow. But it runs the gamut, okay? But how are they hired? They're chosen by who?
These are contractual in nature, like we discussed, and most HOA bylaws empower and authorize the boards to basically review, interview, companies or specific managers.
Who actually makes a decision?
Board
the
members,
homeowners?
board members,
right?
Directors.
Yeah. So the directors sitting on the board make the decision. They've got to vote amongst themselves.
Yeah.
Okay, and decide. Okay, let's say hopefully there's been the bidding process, but let's say they heard from 3, and I'm not going to name any specific ones. I'm not here to tout any management company. There are as in everything, some are better than others, and some are terrible, some are good. We're not going to name anybody. Okay, but let's say, hey, we're looking at company A, company B, company C. For the things that we want, for the scope we want, they're offering a flat rate plus an hourly rate outside scope for this, or a certain amount of hours per month. There's a million ways that HOAs can get charged. There's a million ways to be charged. There's no requirements in the law. It's up to the HOA to decide what works best based on a variety of factors, and that's really well within the business judgment rule for the HOA to decide. Court's never going to, second guess the board on the way they make that decision because it's up to them.
Right.
Okay, but hopefully there's a bidding process and they're looking at more than one. It's not on an insider basis. That's when you get into problems because you need the management company to be independent.
Yeah.
That's a biggie. If they're not, if they're just they're sitting in the pocket of the HOA, it can cause real problems and it can lead to things like embezzlement and other things that we've seen. And you don't want that. But, the board eventually makes a decision and they sign a contract. Usually it'll be the president on behalf of the board empowered to do that. They sign the contract and you hire the management company and boom, bam, there you go. Okay. That's, and these contracts will most often run for a year, but they can be 2-year or 3-year contracts. That's okay.
They can.
I don't see a lot of those. I typically see the 1-year contracts. That's the most common, but I have seen 2-year and I've seen 3-year.
Renewal clauses. Yeah. Exactly. Yeah.
And then there might even, a lot of them will have a automatic renewal clause, although there are some California laws regarding automatic renewals, and so those contracts usually meet the minimum standards. If they don't, and you happen to pick that up as a layperson, that more power to you. I'm not going to go into detail on that. That's a topic for general law and what what can be in a contract. But there might be hey, termination. You can't terminate us without 30 days notice or 60 days notice. So there'll be some termination clause. And once that decision is made, the board has decided on a professional and has reviewed or had somebody review the contract and is in favor of the financing mechanism, how they're going to be paid, they hire them up, they write their check, and they go from there. And the management company starts. And that's typically, that's how they're hired. Now, what's supposed to happen is at the end of, prior to the end of the term, maybe 90 days or 120 days prior to the end of, if it's a 1-year contract, maybe 90 days or 60 days before the end of the term, there's a discussion in the board about whether to renew or open up for bid. I would certainly look at other, just like you do with insurance people, you should be looking at, make them competitively bid for your business every time the contract's about to expire. Make them competitively bid. See if you can get anything. If prices have dropped a little bit or there's more competition in the local arena, there's, other companies that have popped up or solicited to you and they're offering you a better pricing structure, maybe go to your manager and say, hey, we've got an offer from this other management company that's going to do the same scope as you and charge less. We'd like you to match that. I mean, that's supposed to happen.
And ideally, you get feedback from your membership. Are they content with them? Because there's something to be said for continuity.
But you don't have to.
Relationships.
But ideally, the ideal is always the best, right? But they don't have to. The board doesn't have to because you can usually tell. But a good board is going to have their pulse on that.
Yeah.
If the board is hearing complaints consistently from members about failures by the management company. Look, I've written twice about this leak and nobody's calling me back, and that's why I'm reaching out to you. That's a problem.
Right.
And a good board will go to the management company and say, hey, what's going on here? This person's reached out to you. And if that continues, they're terminated. And not even waiting to the end of the term, just terminate them. Okay, I would. So, yeah, but hopefully there's at least a second look, just not automatic rubber stamp rehire at the same pricing or even, step up pricing based on, cost of living increases. Right. No. It should always be competitive because there's always somebody new that's willing to give you a discount if you bring them on. That should be used as leverage. Always. Save money. It's because remember, your boards are fiduciaries to you when it comes to your money. They should be securing your money in a responsible fashion. That includes spending it wisely. That's a fiduciary duty. So what is critical for homeowners, though, is if you haven't already done so, I recommend strongly that you do so, and that is you should have a copy of the current contract between your HOA and the management company. You have a right to it under 5200 of the Civil Code. It's one of the documents you're entitled to. And if you can listen to my podcast on that issue, we have a whole podcast on 5200, and I have an article on my website at mbkchapman.com under the articles section on 5200. So everybody should have a copy of that contract, at least have reviewed it once. Yeah. And you don't have to review it again until it's been renewed or you have a new management company. And again, as Sam said, those get replaced a lot. We'll talk about why.
And at minimum, it'll inform you on the scope, and so you're better informed and you can act accordingly.
Or see whether or not it sounds really like, is this management company paying way too much? Because you can Google, what does a standard management company charge for XYZ? There's a lot of information out there. And if your HOA is paying a lot more than it just seems a little excessive to you, even if you really don't have expertise in this area, if it seems excessive, you can look into it if you want. It couldn't hurt. You have a right to ask. Yeah. That's what a responsible homeowner might do. If you find yourself having time to do it, okay? But that's part of, how long have we had this company, and has there ever been a rebid? Have we ever, at the renewal period, have we ever looked at any other management companies, or have we just rubber stamped rehiring the same one year after year? Because that is one of the red flags. When it's automatic restamp, just rubber stamp, and there's never a rebidding or even a renegotiation of the contract, that's a red flag. It doesn't mean it's a problem, but it is a red flag that it might be a problem, because that's one of the things you should look for, okay? Management companies, I think, to kind of close off this section, shouldn't they be competing for us?
Ideally, yes. I mean, that's probably, to me, a big indicator of how committed are they to serving your community.
Serving,
right?
Serving. Because they're being paid. Okay? They're being paid by us, our money, your money, and your money, and your money, and your money all put together. That is being used, and a large part of it, by the way. I mean, they're not cheap. They're expensive. And if they're doing their jobs, it's worth every penny.
And if there's cumulative apathy, that's a big red flag.
That's a big red flag. Yep. That's right.
Yep.
And so great transition. Let's talk about red flags, because there are red flags when there's something not kosher with your management company, here are some red flags to look for, okay? Routine delays in responding to owner emails or requests.
There you go.
Okay?
Yeah. Mm-hmm.
If, let's say you have an issue come up and it's the Thanksgiving weekend.
Mm-hmm.
It's not unexpected, even though if it's an emergency, that should be pretty quick. But you can understand why, it might take a day or two to have somebody get back to you because they're in the middle of a holiday season. Mm-hmm. And that manager might be out of town with his or her family, right? So context matters, but if it's routine,
right?
If they don't get back to you in a timely fashion, I call timely at least 24 hours. Mm-hmm. Anything more than 24 hours to me is not timely.
Right.
Okay. It doesn't mean it has to be substantive.
It could be an acknowledgement of receipt. Hey, thank you for sending this email.
Exactly.
Yeah, I'll pass it on to the board and I'll get back to you.
Or
as soon as possible.
Thank you for the email. I need to look into this. I will get back to you in the next couple of days, but I'm on top of it. That is not untimely.
Right.
At least acknowledging receipt is they're saying, look, this is not something I can decide right now. I've got some stuff I got to look at, but you've gotten me started. I'll get back to you. That's okay. But if they routinely take 24, 48, or longer hours to get back to you, they ignore you for a week, that's inappropriate. Ever, especially in an emergency. Water intrusion is always an emergency. If water from the outside is coming in, I can't think of a situation where that's not an emergency. Because water from outside should never be inside, unless it's through the pipes coming into your sink into a pot under the faucet, because then you're actually turning on your spigot.
Right.
Water, let me rephrase. Water should not be coming in from unexpected places. And when it does, it's always an emergency. That needs same day recognition. There should even be a 24-hour number, by the way. There should be an emergency number promulgated by your management company that says, hey, if you get a massive roof leak in 2 a.m, here's a number you can call. Doesn't mean you're going to get service. Doesn't mean that somebody with a tool belt's going to be there within an hour, but somebody's going to get that message and it'll be handled in an expedited fashion. Ask if you don't know that number. It should be there. That is, to me, it's below the standard of care not to have that. Okay? So, routine delays. You agree?
Agreed.
Okay. Do you have another one? Another red flag?
Well, another red flag is when your manager essentially makes substantive decisions on things like, let's say, architectural approvals.
Right.
That's a red flag to me.
Right. If they're taking on duties that are non-delegable.
Exactly.
Okay, and I guess we'll talk about those in a few minutes. Well, let's do it right now. Let's briefly take a break and talk about some of the non-delegable duties. Okay? First of all, decisions.
Okay.
Substantive decisions. You can't delegate those. Managers don't get to make decisions about the HOA or its members. They can advise, but the decisions have to be made by the board. So they should not be sitting on the committee, architectural committee, making decisions.
Right.
They can advise the committee as to what's allowed and what's not allowed, but they shouldn't be substantively deciding anything or involved in substantive discussions. We kind of talked about that before. That's non-delegable. They should not be. They can write checks and sign checks as agents of the board, but only for things that they're allowed to write checks for and that the HOAs approve them to write checks for. So, if they can pay the vendors, right? They can write the checks to the vendors, but they are beholden and they have to report the financials to the board, right? So they shouldn't be deciding, you know what, we're going to borrow from reserves over here, just all of a sudden just writing a check, because it has to go through a board decision.
Exactly.
To borrow from reserves has to be at an actual meeting. It has to be discussed in open meeting, and then it has to be included in the minutes, and then in the minutes has to be a funding, and we'll talk about this in a future podcast. It has to be in a funding, here's what we need to borrow reserves for, and here's our plan to pay it back at within the 1 year deadline, which the code sets. They're not the ones that just get to decide, we need to borrow from the reserves. I got to pay this vendor, and we don't have a lot of money here for some reason, so we're going to just write a check from the reserve account. You can't do that.
Right.
Not if you're a manager, okay? So, back to red flags. If they're doing those things.
Omissions such as, let's say they blow.
Well, let's go back to the one you said first.
Yeah.
So you said, okay, one of the things is if they're doing things they aren't supposed to be doing.
Yeah.
If they're making decisions on non-delegable decisions, that's a no. That's a big red flag. Okay, what's this next one?
Well, I guess the way I envision it is a categorical omissions of, let's say, notices or getting things on.
Things aren't getting out.
Agendas.
Right.
You're blowing deadlines, right, in terms of various
so
deadlines.
Remember, we're assuming the full service contract.
Yeah,
so we're going to assume that the duties include making sure notices go out and using templates that they've created, right? If those don't go out, if the required notices or disclosures aren't going out and it's their duty to make sure they do, then that is a big problem. It's a huge red flag. To me, it's more than a red flag. It's evidence of malfeasance. Here's another one, though. Missing records, okay, or refusal to release documents. They're supposed to, let's say they get a 5,200 document demand from you, a homeowner. They're supposed to deliver that to the board. And if the board says, let's say one of the things you're asking for is the management contract, because we talked about that earlier. That is 100% absolutely a contract that every homeowner is entitled to as a matter of law. Okay, and again, I give a list of all the documents that you're entitled to and the code section that gives you that power in the article that I wrote, and we talk about it in the podcast. But in the podcast notes, I might have a list. Can't remember. But if the HOA board says, nah, we're not going to make your contract available, we think that's between us, the board, and you, the manager. The manager isn't supposed to go, yeah, you're right, and then refuse to turn it over. The manager is supposed to go, you can't do that. Okay? And if you don't believe me, ask the lawyer.
Yeah.
In other words, if the manager is facilitating obvious wrongdoing, I'm not talking about stuff that skirts the line where you're not sure whether or not it's covered under 5,200. I'm talking about the bright line things, like it's right in there and it's got its own section in 5,200. And they're saying, nah, that's a problem because they're fundamentally not doing one of their jobs, which is to advise the board on the ins and outs of the Davis-Sterling Act and their requirements. That's one of the whole reasons they exist. Here's another one, another red flag, unexplained late fees or unexplained accounting errors, okay? Errors happen and they can be explained, then they're not unexplained. If they can be explained, well, we screwed up this, but it's been fixed, that's explained, no problem. It's unexplained. We talked about those in the embezzlement episode.
We did.
When it was the manager embezzling, that manager couldn't answer questions because there were no answers. You know why? Because the answer actually was, I'm stealing money.
Incriminating, yeah.
And he, in this case, he couldn't say that, or at least he didn't want to say that because that would have been problematic.
Yeah.
So instead, he came up with these circular, nonsensical explanations that didn't explain anything. Hence, red flag, unexplained.
Yeah.
Okay? Arbitrary enforcement. If the primary communicator or liaison between the members and the board or members and other members is the management company, and there's a breakdown in that it's arbitrary. You have a manager that's clearly selectively in favor of one homeowner over another, that's a problem. They're supposed to be objective. Yeah. They're supposed to treat everybody the same.
Right.
They're supposed to be professional. They're supposed to be non-emotional and objective. Board members are often emotional and subjective. They shouldn't be, but they often are. But they have a dog in the fight. They live in that community. Managers aren't supposed to be. You should not have a management company where the manager or the owner of the management company lives in your community. That's a problem. That's a conflict of interest, and that should never happen. Okay? I don't think it's illegal, but it's a conflict of interest to the extent that I think we could, under that theory of the law, I think we could exclude it. But again, I actually have never seen that, so I'm not going to think. I don't think it's a problem. How about poor communication? So we have routine delays. We talked about that, but poor communication.
That's a big one.
That was the one you brought up, sort of, right?
That's so pervasive, yeah.
I forgot to send out that required notice. Sorry about that. Oh, I'm supposed to give you guys a disclosure on the election rules. Oh, I'm supposed to turn in the election rules for this election within 90 days, right? Or, I didn't do that. That's problematic.
Happens all the time.
Happens every day. Yeah. Every day. How about obstructive conduct during recalls or election or the recall process? It's the management company. I gave an example during our recent podcast on recalls. I gave an example of a management company fighting with, did I give this example? A management company in the recall process trying to argue that the pocket deed was sufficient.
I think you mentioned that, yeah.
Okay, I might not have mentioned it was a management company.
You and I talked about it, yeah.
Right, I can't remember if it was a private conversation I had before we started the podcast or during the podcast, but in that recent episode we talked about that example about what a pocket deed was. And anyway, I gave an example about a case involving that pocket deed issued. I just can't remember if we talked about whether it was the management company that was the cause of the problem, but in this case it really was. The management company was just wrong. They are not lawyers. Okay, they don't have to have any degrees. They could be high school dropouts and work for a management company. There's no requirements on education. They don't know what they're talking about. They're not lawyers. They should know what they don't know, and they should defer when it's appropriate to defer. But they were sitting here just opining, pocket deeds are sufficient, blah, blah, blah. No, you're wrong. Here's the law. And it took the lawyer to finally figure it out.
And the big danger is that a lot of these volunteer lay board members
know.
will acquiesce and defer to them and really treat them as if they're analogous to an attorney opining on legal issues. Yeah.
And then another big one, let's just in case we're running out of time, is vendor kickbacks. We saw that in the embezzlement episode. We saw a lot of that. Okay? But what's the biggest red flag of all? Well, we talked about it. That's the one where you have evidence that your board is delegating non-delegable duties.
Yeah.
If the management company is acting as a de facto board member, that is illegal. There's no question. It's beyond a red flag. It's just a violation of the law.
Right.
If that ever happens, it's not a red flag. It's illegal.
And there's no scope of contract that.
And there's no scope that it could be.
Yeah.
They can't put in there, we will make these types of decisions.
Yeah.
The reason it's called non-delegable is because it's non-delegable, meaning you can't delegate it to them.
Right.
You can't. Even if you want to and everybody loves the idea, sorry, can't do it. So how do you hold your management company accountable? Because remember, you, individual homeowner, are not in privity of contract with your management company. If you ever file a lawsuit, and you see lawyers that don't specialize in lawyers that don't do a lot of Davis Sterling law.
I know where you're going.
Just general litigators that file lawsuits that try to get involved in HOA law, and that's why we take over so many cases that have been filed, and we end up amending the heck out of the complaints. They very foolishly will name the HOA and then name the management company.
Yeah.
That always, anybody competent, if they're going against a competent counsel for the HOA. And that's not always the case. But if they are, there's going to be a demur right there. Because a demur, I won't go into what a demur is other than it's a challenge to the face of the complaint, okay? Because management companies don't owe any contractual privity duty to anybody other than the board as a whole, okay? You don't need to name them, though. What you need to understand is, under California's agency theory, anything the management company does in the course and scope of their duties for the board is as if the board's doing it. So by suing the board, you're suing the management company. Now the board might turn around and make them a cross defendant and sue them for indemnity. In other words, to say, we're now being sued by our homeowners for doing X, Y, and Z, but you're the ones that told us we had to do X, Y, and Z, so we're suing you and saying, if we're liable, you have to pay us, and then we'll pay the homeowner. That's how it's supposed to work. You don't name the management company, okay? So what do you do? How do you hold them accountable?
You pressure the board.
Right. You pressure the board because, again, everything the board does, everything the management company does is deemed to be the board doing it or vice versa. They are agents for the board. Now, if a manager is drunk driving, let's say, and ends up hurting somebody, and there was no, this person didn't have a history of drunk driving, and I'm trying to take away all the potential negligent entrustment issues. Right. The board, that's not within the course and scope of the manager's duties. So that's not going to be something that the board will be held liable for in most cases. That'll be something the manager individually is held liable for. Maybe their company, but not the HOA. But anyway, homeowners need to understand two very important things, okay? Or let's start with one very important thing. You are nothing to the manager, and the manager is nothing to you other than a spokesperson for the board. Okay? They are an agent of the board. They don't owe you anything individually unless it's by and through their scope of work that they've taken on behalf of the board. The board has said, we want you to communicate with our neighbors. They have a contractual duty with the board to communicate with you. Okay? But that's where it ends. They don't owe you anything else, and they certainly don't owe you any fiduciary duty. So, taking into account, or remembering to take into account the fact that your management company is not in privity of contract with you. If you think your management company is crossing the line, here's what you can do. Number one, request the management contract. We talked about that earlier. Yeah. Mm-hmm. Request other documents as well if you want them, but request that contract. You're entitled to it under 5200, and go ahead and review the term, the scope, and see whether or not they're abiding by, okay? 2, request board minutes where the management company was approved. At some point, the management company was initially approved, or if the management company's been there for years, look at the last meeting where the management company was appointed. So if it's a 1-year contract, you should look a year earlier, right?
Be a prior board, yeah.
So ask for all the meeting minutes for the last 2 years, let's say, and that will certainly give it to you. If you don't find anything in there, that's a problem, because that means there was no rebidding and it was automatic rubber stamp renewal. There should at least be a discussion. The discussion could be, they're doing a great job. They are great pricing. We haven't gotten any better offers, and so we're not going to rebid it. We're happy with the work they're doing. We haven't had any complaints. We're going to go another year. That's in the minutes, that's acceptable, okay? It might not be best practice, but it's not illegal,
Right.
okay? Organize other homeowners, okay? This is beyond powerful, folks. If you have a right to the membership list, unless people have opted out and 99% of a population hasn't, you're entitled to email address as well. You could put together a beautifully written email, 3,000 words, 4,000 words, however long you want it to be, and get it out to every member of the association. And that's where you can say, look, I have these concerns, X, Y, Z. I asked for these documents. I reviewed these documents. Here are some red flags I found. This is costing us money. Say what you want. Tell your story. Urge them to join you in getting put onto the next agenda of an open meeting, a discussion about all your concerns. Or demand an IDR meeting and have other homeowners appear with you. Or get together a recall petition. We just did a podcast on recalls. Mm-hmm. Your ability to communicate with your fellow members and get them on your side is extremely powerful. And sometimes it takes work to get people interested because they have their own lives to live. But if you can bring people to your side, you can change everything. I've seen homeowners band together and force the resignation of entire boards of directors without ever having to go through a recall. They were ready to, but these people just resigned because they knew it was a foregone conclusion. Mm-hmm. Okay? I've seen it work miracles. So it is real and it does happen. Okay? Demand your board bid every time a contract is going to expire. Doesn't mean that the current management company won't stick around as long as they outbid the others.
Right.
Hey, if they say, look, go ahead and open us up for bid, but we love you guys, we'll match any price you get from somebody else if it's in writing, you might end up sticking with the board or sticking with that management company. That's fine. But at least demand that your HOA open it for bid.
That's likely to get them to elevate their game.
Exactly.
Yeah.
Okay? Only if they think you're attacking them, and that's a small person, will it not be received properly. Yeah. Otherwise, it should be received the manner in which it's given, which is, you guys are being complacent. I don't want to be complacent with our money. Let's be more proactive. Mm-hmm. And again, we talked about you can use IDR strategically if you need to. So let's close with this. Okay, management companies serve an important function in modern HOA life. They serve a very useful function and they're important. But if the management situation is abused, if your management company is inept, if there's no bidding, if there's no supervision as to what they're doing, if they are taking on duties that they are not legally allowed to take on, if they're making decisions they aren't supposed to make, that's when abuses occur because they are not subject to the democratic process of voting and electing. They aren't subject to recalls. They aren't subject to any of that like board members are. So while they serve such an important purpose, it has to be within the confines of the law and within the confines of the contract, because that's what's supposed to spell out what they're allowed to do and what they aren't allowed to do. So the good news is you as California homeowners have complete transparency when it comes to what these managers have been hired specifically to your HOA to do. You can find all that out. You're entitled to all that information. You're entitled to take that information and seek the help of fellow homeowners. You're entitled to demand that issues be put onto the agenda. You're entitled to do all these things to ensure that your HOA is utilizing management companies in the best way possible. And if you are involved, you stand a much better chance of not falling into a situation where embezzlement can happen or where people's rights are being just violated. Okay? And that things that are supposed to happen, like certain notices, are going out properly. Hold the management company to their obligations and to what they're supposed to be doing, and you go a long way toward fixing any of the problems that your HOA might be having. And if none of that's enough, that's when you come to us at MBK Chapman, because we're experts at holding your HOA accountable. This has been another episode of HOA Hell, and if you like this episode or found it helpful, please hit the like button. And if you haven't already done so, please subscribe to the channel. And if you'd like to leave a comment or ask a question, as always, we're very happy to hear from you. And until next time, have a wonderful day.